So, good day class. This will be our final lecture for this semester. Last meeting, we were able to discuss the extinguishment of sale. And for our last topic for this semester, we were going to discuss the warranties in the law on sales. Okay, what is a warranty? In layman's term, what is a warranty? Warranty is like an assurance or guarantee or ginagarantiya, ina-assure or wina-warranty or ginagarantiya ni seller. An assurance or a promise or a guarantee by one party that a particular statement of fact is true and may be relied upon by the other party. Therefore, breach or violation of that warranty or assurance or guarantee or garantiya will give rise to a suit for damages. Okay? Take note, warranty is enforceable only against the immediate vendor of the party dispossessed or party na damage. Okay. What are the two kinds of warranties? So there are two kinds of warranties pala. We have the express warranty and we have the implied warranty. So dalawang klase express. Just like your extinguishment of sale, merong conventional, merong legal redemption. No? Pag ganun din sa warranty, parang merong express. This express, ibig sabihin, by agreement, no? Or by the express statement of fact by the seller, pinawarranty niya ngayon, ginagarantiya dahil sa sinabi niya or nakalagay sa kontrata nila. That is an express warranty. Pag wala namang nakalagay sa kontrata nila, pwede pa rin magkaroon ng warranty. Yan naman yung tinatawag na implied warranty. Kasi kahit walang sinabi si seller, as provided for by law, as by operation of law, sinasabi ng batas, merong warranty. May implied warranty. So, what is the definition of express warranty muna? What is express warranty? So, what is an express warranty? Sabi sa law, by definition of the book, an express warranty is an affirmation. Ina-affirm. Affirmation of fact, or kung hindi man affirmation, promise. Any promise made by the seller about the subject matter of the sale, where the natural tendency is to induce, no? Because of the affirmation, express affirmation of fact by the seller, or kung hindi affirmation, nag-promise si seller na ganito yung fact ng subject matter, na-induce ngayon si buyer na bilhin yung object because of that affirmation. Ibig sabihin, kung wala yung affirmation, kung wala yung promise, hindi bibili ni buyer yan. That is an express warranty. So by definition, express warranty is an affirmation of fact or any promise by the seller about the subject matter where the natural tendency of it is to induce the buyer to purchase the thing, and the buyer purchases the thing relying on such affirmation or promise, no? So kaya na binili yung object, subject matter or thing ng sale because of the express affirmation of fact or any promise made by the seller. So example of an express warranty, for example si A alahero siya, expert siya sa mga alahas, alam niyang kumilatis kung anong peke sa hindi, no? And alahero nga siya, nagbenta ngayon siya kay B ng alahas. Si B, knowing na expert si A sa alahas, no? Kasi kakaibigan niya, alahero nga siya. Sabi ni A, bilhin mo na to B. Kasi ito, talaga to, 24 karat gold, no? 24 karat gold, sigurado ako 24 karat gold. Because of that affirmation, sigurado siya, sinasabi ni A, no? Si B, na-induce siyang bilhin ngayon. Relying on the statement of A, since A is an expert sa alahas, no? Nag-rely siya sa statement ni A and kaibigan niya. That's why binili niya, no? Kasi kung wala yung statement ni A, hindi niya bibilhin kasi hindi siya sigurado. Pero dahil kaibigan na si A at expert si A sa alahas, alam niya na original yun, na 24 karat yun, binili niya, no? Later on, it turned out na peke pala, no? So that is an express warranty made by the seller A, therefore liable si A. Okay, ganun ang concept, no? Express warranty. Take note, express warranties that does not apply to a second-hand purchase of second-hand articles, no? Does apply pala class, does apply. Kasi ang general rule, ang second-hand na object, walang implied warranty. Against hidden defects, walang ganyan yan. Kahit na defective yan, hindi mo na maano yan kasi second-hand mo binili. Pero pag yan, express warranty, binenta sa'yo yung second-hand item, express warranty, no? Pwede siyang pumasok. may warranty siya ngayon pag express warranty. Ang second hand article, walang warranty, walang implied warranty. As to hidden defects, any kinds of implied warranty, wala. Pero pag yan in-express by affirmation of fact by the seller, by the promise of the seller, no, kahit second hand article yan, papasok ang liability ni seller. Okay. Nakikinig kasi yung misis ko, no? May tanong siya. Sabi niya, kailangan daw ba written, verbal, yung affirmation of fact? Hindi naman kailangan kasi ngayon pwede na rin acceptable ang electronic evidence, no? So pag na-record mo siya, na-videohan mo siya, pwede naman. Pwede ng evidence yun ngayon, no? And na-record mo, pwede naman. Example nun, no? Example ng second hand article. So for example, bibili ka ng second hand car. Later on, pag uwi mo, defective pala, generally, hindi mo may babalik yan, no? Hindi mo na may babalik yan kasi nga, walang warranties yan Kasi second hand article yan Pero, ibang usapan pag may express warranty. Like, for example, chinek mo. Tapos nakita mo, parang palyado naman tong makina niya. Sabi ni seller, hindi, kakapagawa ko lang yan, bago yan. That is an affirmation of fact, no? So, later, umuwi ka, defective pala yung makina, pwede mong habulin ngayon kahit second-hand article because may express warranty si seller, no? Pero general rule, second-hand articles, walang warranties unless may express affirmation or may promise si seller that would amount to express warranty, therefore liable si seller for that purpose. Okay. So iba naman ng expression of an opinion only. Iba yung affirmation sa expression of opinion, no? Like for example, yung sa example natin kanina, na-induce si B buyer ng alahas kasi expert yung kaibigan niya sa alahas Pero ibang usapan pag hindi expert, no? Mere opinion niya lang. For example, si Mr. A, instead na alahero siya, no? Magsasaka siya. Later on, nakapulot siya ng singsing. And then, pinakita niya kay B. Sabi ni B, peke yata yan Sabi ni A, hindi, totoo to, gold to, 24 karat ganun ba? Ngayon binili ni B, no? Relying on that statement, is that an affirmation of fact? No. Sabi ng batas, mere expression of an opinion made by the seller does not constitute warranty. Sa opinion niya lang no? Unless, ang exception dyan class, unless the opinion was made by an expert for that purpose. Expert ba siya sa alahas? Hindi. Magsasaka siya, farmer siya no? So, sa general rule siya, mere expression of an opinion does not constitute an expressed warranty. So, in that case, hindi pwedeng gamitin ni B as a defense na kaya ako binili kasi sabi niya fake, original. No. You are, para kang bad faith ka rin, negligence ka sa part na yun, Bakit ka maniniwala sa kanya? Diba? So, ganun ang concept na yun. Piloso po tong misis ko Sabi niya, paano daw kung dati siyang alahera, naging farmer? Paano nga ba yun? Hindi ko alam, bahala ka na. Bahala na kayong sumagot pag gano'n ng question, no? So, we're done with express warranty. What is now the definition of an implied warranty, no? So, an implied warranty is a natural element. Di ba, naalala nyo sa elements, no? There are essential elements, there are natural elements, no? So, ang warranty, ang implied warranty, it is a natural element. When you say natural, it is embedded. Andyan na yan, no? Kahit walang agreement, natural siya na part siya, andyan na yan. Natural element of a contract of sale and is deemed incorporated in a contract of sale. It is inherent, no? Sa contract of sale. Hindi pwedeng i-deny yan. Its reason is to protect. Bakit nagkakaroon ng implied warranty? Bakit nag-provide ang batas ng implied warranty? The purpose of this is to protect naive, unsuspecting buyers from scrupulous sellers, no? From running away from their wrongful doings, no? For the protection of the buyer naman yan. It may be modified or suppressed, no? So, ang implied warranty pala, pwedeng ma-modify by agreement, pwedeng tanggalin by agreement, pero pag walang agreement to that effect, implied warranties will exist, no? So, what are the different kinds of warranties? Implied warranties. We have this, so, enumeration of implied warranties in sale. Warranty, implied warranty as to seller's title, no? Pag yan nagbenta, impliedly, siyang may-ari niyan, no? Kasi hindi ka na magbebenta ng hindi sa'yo. Or kung hindi siya yung may-ari, may karapatan siyang magbenta kasi ahente siya. So, may binenta sa'yo, implied warranty na siya ang may-ari. Hindi na pwedeng sasabihin, binenta ko, hindi naman ako may-ari. No. Di ba? Illogical. Kaya ako binenta kasi ikaw may-ari. No? Take note, di ba, ang ownership importante sa delivery. No? Not at the time of sale. Paalala ko lang ulit. So, implied warranty as to the seller's title, or hindi man siya yung may-ari, meron siyang karapatang ibenta. Right to resell. Right to sell. Okay? Second, warranty against eviction. I'll discuss natin in detail later. Third, warranty against non-apparent burden or servitude. Example, right of way. Later yung elements. Detailed explanation later. So number 4, warranty against hidden defects. This is the common, no? This is the most common type of implied warranty. Warranty against hidden defects. Number 5, warranty as to fitness or merchantability. Ano yun? General merchantability. Pag bumili ka ng cellphone, impliedly, makakatawag ka sa cellphone. Yun yung fitness, no? Bumili ka ng sasakyan, makakapag-drive ka ng sasakyan, tatakbo yung sasakyan for that purpose, fitness or merchantability. Okay. Warranty against redhibitory defects of animals. So, yun yung number 6. So, general rule, pag nagbenta ka ng object, may implied warranty yan, no? May implied warranty yan, yung enumerate ko kanina, implied warranties, no? But there are exceptions wherein there are some contract of sales that does not have an implied warranty. Yung example ko kanina, second hand, no? Pag bumili ka ng second hand, walang implied warranty yan. In addition to that, yung meron tayong tinatawag na as is, where is sale. Yung mga as is, where is sale. As is, ibig sabihin, kung ano mo siya nakita, yan na yan, no? Provided meron si buyer na meron siyang chance na ma-inspect yung object. As is, kung ano yung condition niya, as is, where is, kung nasaan siya, doon mo kukunin. As is kung ano yung itsura niya that time, nakita mo, bilhin mo. Hindi mo pwedeng sabihin dito yung defective, no? As is denotes that the seller is selling and the buyer is buying an item in whatever condition it presently exists, and that the buyer is accepting the item with all faults, whether or not immediately apparent. Okay. Ganun ang concept, no? So, general rule, may implied warranties, except as is, where is sale, and selling of second-hand articles, like selling second-hand cars. We now go to warranty against eviction. What is eviction? When you are being evicted, no? When you are evicted, yung mga nasa bahay ni kuya, when they are evicted, anong nangyayari? Napapaalis sila. So, eviction in the contract of sale is where the buyer or the vendee is deprived either whole or part of the purchase of the subject matter. So, ang eviction, ang nangyari dito, si buyer, na-deprive siya, na wala sa kanya yung binili niya. Usually, lupa tong eviction. Sa lupa siya nag-a-apply, usually. Pero pwede rin naman. So, eviction, pag na-evict si buyer, na-deprive siya either whole nung property or part, that is eviction. Pwede siyang humabol ngayon kay seller sa warranty ni seller against eviction. So, warranty against eviction is where the seller guarantees that he has the right to sell the thing sold and to transfer ownership to the buyer who shall not be disturbed, no? Kasi bibili ka ng lupa tapos maraming manggugulo sa'yo. So, you are protected by the warranty against eviction, no? By the seller. That the buyer shall not be disturbed in his legal and peaceful possession thereof. Therefore, if evicted, vendor is liable thereof. Pero hindi automatic. May mga elements ang warranty against eviction para magamit siya as a right against the vendor. Para ma-establish ang liability ni vendor for warranty against eviction, we have these elements. Okay. You take note of these elements kasi lacking ng isa, hindi pwedeng magamit ang warranty against eviction. So we have 5 elements. Number 1, the vendee has been deprived. So, nawala sa kanya yung property, usually property, either buong property or part ng property na binili niya, na deprived, nawala sa kanya. Second element, yung deprivation is by way of final judgment. Take note, ang deprivation should be by virtue of final judgment. Ibig sabihin, dumaan sa korte yan, nagdesisyon na yung court by final judgment. Kailan ba nagiging final judgment? Kasi sabi dito, hindi lang judgment. Sabi dito, final judgment. So may decision ng court, may right to appeal, nag-appeal, natalo. Tapos hindi na nag-appeal later on sa higher courts. Or may decision ng court, hindi nag-appeal within the reglementary period, within the prescribed period to appeal, therefore magiging final yung judgment. So yun ang element. Number 1, na-deprive si buyer, either whole or part. Second, yung deprivation is by virtue of a final judgment rendered by the court. Judgment, final. May judgment, nag-appeal, natalo ulit, hanggang sa naging final. Or may judgment sa, gano'n kasi yung kasi, so pag nag-file ka ng case, no? From RTC, or pwedeng MTC, depende sa amount. Pwedeng sa municipal trial court, pag natalo ka, mag-a-appeal ka, punta sa regional trial court. Pag gusto mo pang umapil, pwede kang pumunta sa Court of Appeals. Kapag natalo ka ulit doon, gusto mo pang umapil, pwede kang pumunta sa Supreme Court. Yun ang pinaka-final sa Supreme Court. Pero dito pa lang, for example, sa RTC, natalo ka na, ayaw mo na mag-appeal, nag-lapse na yung period mo to appeal, magkakaroon na ng final judgment. No? So, yun yung requirement. The deprivation should be by virtue of final judgment. Third, judgment is based on prior right to the sale or act imputable to the vendor. No? Yung issue nag-i-exist bago magkaroon ng contract of sale. No? So, nag-i-exist yung right ng ibang party. Kasi, in-evict ka ng ibang party eh. Yung third person na nag-evict sa'yo, may karapatan siya bago nagkaroon ng bentahan sa inyo ni seller, between the seller and the buyer. Okay. Number 4, this is very important, number 4. Kailangan pala para magkaroon ng warranty against eviction, the vendor, no? So, may nagbenta kay buyer. Yung vendor, si seller na yon, must be summoned in the suit for eviction at the instance of the vendee. What is that? Napaka-technical. What is that? Napaka-technical. Ibig sabihin yan, class, kasi umabot sa korte yan, no? Usually, pag binigyan si buyer, no, susulatan ng korte, si buyer na dinidemanda siya ni ganito, dapat ipasok niya sa case. Ipasok niya sa case si seller na nagbenta sa kanya. Sasabihin ni buyer doon, binenta sa akin ni seller, isama mo siya sa case. Ipasok mo siya as a third party complaint, third party defendant, or dalawa kaming liable. Dapat ipasok pala sa case. Otherwise, pag hindi mo pinasok sa case, vendor was not summoned, no, in the suit for eviction, si buyer ngayon wala siyang karapatan para gamitin yung warranty against eviction. This is very important. Take note of this. The vendor was summoned in the suit for eviction at the instance of the vendee. Paano yun? Pag dinimanda si buyer, susulat si buyer sa court, sasabihin ni buyer, dapat po isama po natin sa case na to si seller as third party defendant or kasama ko pong defendant, co-defendant. Kasi pag hindi mo ginawa yun, buyer, later on natalo ka, wala ka ng habol kay seller. This is very important. Okay? And take note, and last, there's no waiver on the part of the vendee. Walang waiver kasi pwedeng i-waive ang implied warranty, no? So hindi niya wini-waive yung warranty against eviction. Okay. So what if naman there is waiver, no? There is waiver on the part of the vendee, no? There is waiver on the part of the vendee that he will not claim the warranty against eviction, no, to the seller. Pwede bang i-waive yung warranty against eviction? Pwede naman daw, yes. But what if there is bad faith? Bad faith on whom? What if bad faith si vendor? So kahit na winave pala yan ni vendee, pag bad faith si vendor, alam niya na prior, no? Alam niya na previously na may pwedeng humabol kay buyer kasi nga may nakiklaim na iba, bad faith siya. Therefore, kahit may waiver sa part ni buyer, liable pa rin si seller, no? Okay. Paano pag ang bad faith si buyer, no? Tapos winave niya. So, pag bad faith si buyer, kaya nagiging bad faith si buyer? Si buyer ang may alam. Si buyer ang may alam na may nakiklaim na iba yan. Yet, winave pa rin niya yung warranty, no, against eviction kay seller. Therefore, hindi siya makapag-claim, no? Hindi siya makapag-claim later or pag natalo siya sa case, hindi siya makapag-claim later on kay seller, no? Kasi winave niya, bad faith pa siya. What if they are both in bad faith, no? Ibig sabihin, alam nilang dalawa, yet winave pa rin ni buyer yung right against eviction, warranty against eviction. Bad faith din si seller kasi alam niya din na may hahabol nga. Pag ganun, class, both bad faith, makapaghabol pa rin si buyer, no? Kahit winave niya at bad faith siya. Basta tandaan, pag may bad faith kay seller, automatic makakapag-claim pa rin si buyer kay seller. Pag na-deprive siya, na-evict siya. Take note, however, yung requirements, no, yung elements. The 5 elements must be satisfied, no, para makahabol ng claim against the seller for warranty against eviction. Okay? So what if na-evict and ano yung claim ni buyer kay seller, no? In case eviction occurs, the vendee, the buyer, shall have the right to demand of the vendor, the seller, the following: return of the value of the thing, the income or fruits of the thing, karapatan din ni vendee yun. Cost of the suit, gumastos siya, no? Kasi dinimanda siya, pwede niya singilin kay seller yun. Expenses of the contract, pag ginastosan niya, pwede niya singilin kay seller. Let's proceed with the warranty against hidden defects, no? So parang kanina, there are requisites, no, elements for the warranty against eviction to be established para magkaroon ng claim for warranty against eviction. Ganon din sa warranty against hidden defects. These are the requisites for warranty against hidden defects. So, number 1, defect must be important or serious. So, hindi pala lahat ng klase ng defect pwede mong i-claim. Must be important and serious. What is important and what is serious, no? Later on, i-discuss natin yung important or serious. Pero logically, dapat yun ma-relate sa object, no? Such that it diminishes, no, yung value ng thing, or hindi mo na magagamit yung thing for its intended purpose. Yun. Magiging serious or important yung defect sa isang object kapag yung purpose nun, the intended purpose for which it was bought cannot be used na. Or otherwise, magagamit mo pa rin siya for that purpose pero it diminishes, no, yung kanyang use because of that defect. Sabi defect, no? The defect must be important or serious, number 1. And must be hidden. Hidden defect. Warranty against hidden defects yan eh. Hindi niya winawarrant yung apparent defects, yung patent defects, hindi. Yung hidden defects lang. Bakit hindi binawarrant yung apparent defects? Kasi kitang-kita. When you say apparent, kitang-kita. Defective yet, binili mo pa rin. So, pag apparent yan, class, binili mo pa rin, that is impliedly waiving yung right for that matter, no? So, ang binawarant mo lang, yung hindi mo nakikita. Yung binawarant lang ni seller, yung hindi nakita ni buyer. Hidden defect na yan. And the defect must be important or serious. And it must be hidden. Hindi pwedeng apparent. Okay? And must exist at the time of sale. Paano papatunayan yan? Case-to-case basis. Pero ang ano yan is, nasira yan, hindi sa negligence, no? Kasi baka naman kiniklaim mong defective kasi in-overcharge mo pag uwi mo. So, you are liable negligence, no? Ibig sabihin, nag-exist yan at the time of sale. Okay? The vendee, take note. The vendee must give notice of defect to the vendor within reasonable time. So, pag bumili ka ng object, ipapakita mo na after 1 year, hindi naman, no? Kailan ba yung reasonable time? Depende sa object. Within a day, 2 days, 3 days, depende. Case-to-case basis, baka naman galing sa malayo, pwede naman. Pero hindi naman yung months or years, hindi na. Okay. So, vendee must give notice of the defect, no, to the vendor within reasonable time. What is reasonable is case-to-case basis, depends on the appreciation of the court, no. Number 5, the action for rescission or reduction in price. So, there are two alternative remedies. Rescission, pwedeng ipa-cancel, or reduction in price na lang pwede. Must be brought within 6 months from delivery. Or kapag animals naman yung binili mo, defective, within 40 days in case of animals. So, general rule, the rescission or the reduction in price must be brought within 6 months from delivery, except if in case of animals, 40 days from delivery. Okay? And lastly, there's no waiver of warranty kasi pwede rin i-waive yung warranty, no? There's no waiver on the part of the vendee. So, defect must be serious and important, must be hidden, must exist at the time of sale. The vendee must give notice of the defect to the vendor within the reasonable time. The action for rescission or reduction of price or quanti minoris must be brought within 6 months from delivery and 40 days in case of animals. No waiver of warranty on the part of the vendee or buyer. Alternative remedies of the buyer. We have the so-called action redhibitoria or withdraw from the contract, or action quanti minoris, or you will not withdraw from the contract but the price will be reduced, reduction in price. So when defect is important, sabi ko nga kanina, so hindi lahat ng defect pwede mong magamit as a defense, no? As a right to claim warranty against hidden defects. Kasi yung defect lang na sinasabi natin, class, must be serious and important, no? Such that it renders the thing sold unfit. So hindi mo na magagamit yung object na yun for its intended purpose. Or magagamit mo rin pa rin siya for its intended purpose, but it diminishes its fitness for such use. Example, what could be a good example, no? Cellphone, no? Defective. Yung camera, hindi ka na makapag-picture, pero makapag-text ka pa, pwede mo ibalik? Yes. Kasi though maraming function ng cellphone ngayon, no? Pero isa yan sa mga functions niya. So therefore, it diminishes its fitness or use. Pwede pa rin i-claim, no? Basta hidden, hindi apparent, okay? Next kind of warranty, implied warranty, we have the so-called implied warranty as to fitness or merchantability. Merchantability meaning it's a warranty that the goods are reasonably fit for the general purpose for which the same are sold. It is fit for the general purpose. Yung purpose generally, no? Ano ba ibig sabihin yun? Ano ba yung may special purpose ba yan? Yes. So pag bumili ka ng kotse, general purpose niyan, makapag-travel ka, no? Faster, no? Kaysa maglakad ka, no? Yun naman ang purpose, di ba? Kaya bumili ng kotse. So generally, fit siya. Fit siya na mag-travel from one place to another for a brief time rather than maglakad ka, no? Mas mabilis sa bike, mas mabilis sa motor, no? Pero ano yung example ng special purpose? Like for example, bumili ka ng, si A, bumili ng, anong bang tawag doon? Anong tawag doon namin sa pagong? Kotse pagong? Volkswagen. Pero ang tamang pronunciation daw doon Volkswagen. Volkswagen yata, no? Volkswagen na kotse. Bumili ka ng Volkswagen na kotse, no? Binili mo kay Mr. B. Ngayon, dinidemanda mo si B. Bakit? Kasi pinang-race ko eh. Natalo ako, ang bagal-bagal, no? That is the special purpose, no? So hindi mo pwedeng ibalik 'yan, no? Kasi ang bumili ka ng kotse generally for the merchantability, for the general fitness, pwede kang pumunta from one place to another. Ang special purpose niya na sinabi, na hindi naman niya sinabi kay B, is gagamitin pala niya sa racing, no? Natalo siya because of that. Ngayon dinidemanda niya, warranty as to fitness and merchantability. No. Kasi ang warranty as to fitness or merchantability for the general purpose only, no? Kung ano yung general purpose kung saan siya gagamitin yung object, yung subject matter. Yung ano naman class, iba naman yun pag yung may special purpose ka, tapos nirelay mo kay seller at ginaranty niya, mag-turn out yan na express warranty later on pala. Therefore, liable siya. Kasi may special purpose yung sinabi. For example, ano ba example niya? O yan na lang, horse. General purpose, ba't ka ba bumibili ng horse? Pwedeng pang racing, pwedeng pang farm, no? Bumili ka ng horse, hindi mo sinabi kung for what purpose bumili ka ng horse. Ngayon, ginayad mo pala pang racing, natalo ka ng 1 million. Ngayon, dinidemanda mo si seller kasi nahuli siya, ang bagal-bagal ng horse pala. Pang farm yung binili mong horse, hindi mo naman sinabi na pang racing pala, no? So therefore, hindi siya pwedeng maging liable. Pero pag yan nagbi-breed siya talaga ng horse, then bumili ka ng horse na pang racing mo talaga, alam niya, that is a special purpose, at ginaranty niya na ganito siya, pang racing talaga to, therefore, pwede kang mag-claim pag hindi siya tumakbo or what, no? Pero iba yung general purpose sa special purpose, no? Tandaan, class. O, siguro sa manok, pwede yan sa manok, no? Yung mga panabong. So generally, there is no implied warranty of fitness for any special purpose or any special or particular purpose except under the following, no? The buyer expressly or impliedly manifests to the seller the particular purpose, the special purpose of the goods acquired. Sinabi mismo ni buyer kung saan nagagamitin at si buyer relies upon the seller's skill or judgment, no? Therefore, liable siya for special purpose. Pero generally, pag walang sinabi, yung binili mong object for the general purpose for which it is intended lang. Okay? I hope nasusundan yun, class, no? Siguro I can relate to that, pero I don't think you can relate with me kasi hindi na yata ganun applicable ngayon, no? So, share ko lang. Dati nung sa desktop kasi, Sa desktop, maglalagay ka ng games, no? Maglalagay ka ng games. May desktop ako nung college ako. Bumili ako ng game, no? Tinanong ko yung seller kung gagana ba to sa mga desktops. Sabi niya, oo. So, pagsalpak ko ng CD, no? Hindi gumagana, ang bagal-bagal. Yung pala, kailangan pala sa higher, no? Sa higher version, no? For special purpose na yun, di ba? Kasi ang laptop, ang ano naman, general purpose, yung laptop, desktop, no? Pero yung for gaming na pala yun. Kailangan ng video card. Meron pa bang ganun ngayon? Video card yung term eh. And kailangan yung processor niya mataas pala. So that is a special purpose. Okay? So, hindi ko naibalik. Although, naibalik ko naman siya pala. Naibalik ko naman siya kasi gusto naman niya. Pumayag naman siya. Pero generally, hindi, no? Kasi hindi mo sinabi kung para saang purpose, no? Okay. Warranty in case of sale of animals, redhibitory vice or defect. A defect which the seller is bound to warrant in animals, the following special rules shall apply. The defect must be hidden. Sa animals pa rin to, ah. So, ang defect niya must be hidden, must be of such nature that expert knowledge is not sufficient to discover it. So, the veterinarian is liable if he fails to discover or disclose the hidden defect through ignorance or bad faith. Seller is liable if animal, general rule, seller is liable if animal dies within 3 days after its purchase due to a disease that existed at the time of sale. How will you know that it existed at the time of sale? A case-to-case basis, based on depende sa circumstance of the case, no? Kung wala ka naman ginawa, wala ka naman negligence, basta namatay na lang bigla, the presumption is nag-exist yung disease at the time of sale, no? Kailan walang warranty against hidden defects ang sale of animals, no? Animals sold at public fairs or public auctions. Parang ganun din sa sale as is where is. Livestock sold as condemned, no? May mga ganun, condemned animals. Ano ba yung rule naman pag dalawa tapos hindi siya fit? Okay. Tingnan natin yung provision sa book. Ano sinasabi sa book about yan? Sale of animals. I will read that. Sale of animals. Sabi dito, 1572, Article 1572. If two or more animals are sold together, whether for a lump sum or for a separate price for each of them, two or more animals binenta either for a lump sum price or may price each, the redhibitory defect of one shall only give rise to its redhibition sa isa lang. Kung may defect, redhibitory defect yung isa, sa isa lang, no? Hindi mo pwedeng ibalik yung isa. General rule. Bumili ka 2 or more animals, defective yung isa, general rule, ang pwede mo lang ibalik yung isa na defective. And not of the others. Ibig sabihin, hindi mo pwedeng ibalik yung hindi defective. Unless, so may exception, unless it should appear that the vendee would not have purchased the sound animal or animals without the defective one. Paano naman yun? Ibig sabihin, pag may exception, pag mapatunayan lang ni buyer na hindi niya naman bibili niyan kung may defect yung isa. Ibig sabihin, bibili niya yung dalawang yan kapag hindi defective yung dalawa. Like for example, no, ang purpose niya, kaya siya bumili ng babaeng kabayo at saka lalaking kabayo, para mag-breed, para padamihin sila, no? Ngayon yung lalaking kabayo pala na binili niya, sabay niya binili sa isang seller, yung kabayo pala na lalaki, baog. So hindi pwede ba? Nababaog ba ang kabayo? I don't know. Example lang. So baog, hindi siya sterile or hindi siya makapag-produce ng babies. Okay. So, binabalik niya ngayon yung isa. Kasi yun lang yung defective. Hindi naman baog yung babaeng horse. Okay. So, anong effect? General rule, isa lang ang pwedeng ibalik kasi isa lang ang defective. Unless, exception, patunayan lang ni buyer na kaya niya binili kasi yun kasi ang purpose niya is mag-breed. So, therefore, pag defective yung isa, basically, hindi niya rin magagamit yung isa. Ibalik niyan, dalawa. Pwede. Okay. Last one class, easement, no? Warranty against encumbrance or servitude. What is an easement? What is a servitude? Easement or servitude is an encumbrance imposed upon an immovable for the benefit of another immovable owned by different person. No? Parang to. Ito yata yung pinag-awayan nung sino ba yun? Yung binaril? Yung police, taga Paniki na taga Ordaneta pala, no? Right of way yata, parang right of way yung concept nito, class. No? Easement of servitude. Pag bumili ka ng lupa, no? Tapos di mo alam, wala namang hindi naman apparent na meron palang right of way kasi ang sa batas, class, you are obliged, no, to give right of way doon sa anong tawag doon, nakalimutan ko na yung ano. Basta yung may dominant, may ang tawag doon ba? Nakalimutan ko na, class. Basta may dominant estate, may servitude estate yata ang tawag doon. Correct. May dominant estate, may servitude estate. You have to give right of way, no? Doon sa servitude estate. Yan yung right of way concept. So, sa law nyo na pag-aralan yung concept ng right of way. Pero ganun yan, class. Pag bumili ka ng lupa, hindi mo alam, hindi naman obvious, wala naman nakalagay sa titulo na may burden na right of way or servitude, pwede mong habulin yan kay seller. No? Warranty against encumbrance or servitude. Kinds of easement or servitude: apparent easement, expressly made; non-apparent easement, no external indication of its existence. No? Pwede kasi yung right of way, apparently made, kitang-kita mo, visible, talagang dinadaanan nila. Tapos may sariling muhon yan, sa title, may sariling yan, walang nakalagay na naka-separate na yung right of way. That is an apparent easement. Non-apparent, no external indication, tignan mo, wala naman, parang wala naman. No, wala naman, tapos wala rin sa title. Tapos later on pala, nung pagpunta mo na, meron pala, sinasabi nung kabimang bahay, right of way namin to wala kaming daan sa likod. Easy access sa road, dito lang. No? So therefore, may problema pala, may encumbrance, may burden, may right of way issue. Pwede mong habulin yan kay seller. Warranty against servitude, encumbrance. Requisites for vendor's liability for immovable sold with easement. Again, number 1, must be non-apparent. Sabi ko nga, kasi pag apparent yan, no, as if winave yan. So, pwede mo maklaim yan pag non-apparent, hindi obvious. Not indicated in the agreement, must be of such nature that the vendor would not have acquired the immovable had he been aware thereof. Okay. That's it. I think that's it. So, good luck, class, on your final exam. Okay, goodbye. Last one, class, easement, no? Warranty against encumbrance or servitude. What is an easement? What is a servitude? Easement or servitude is an encumbrance imposed upon an immovable for the benefit of another immovable owned by different person. No? Parang to. Ito yata yung pinag-awayan nung sa, sino ba yun? Yung binaril? Yung police, taga Paniki na taga Ordaneta pala, no? Right of way yata, parang right of way yung concept nito, class. No? Easement of servitude. Pag bumili ka ng lupa, no? Tapos di mo alam, hindi naman apparent na meron palang right of way kasi ang sa batas, class, you are obliged, no, to give right of way doon sa anong tawag doon, nakalimutan ko na yung basta yung may dominant, may ang tawag doon ba? Nakalimutan ko na, class. Basta may dominant estate, may servitude estate yata ang tawag doon. Correct. May dominant estate, may servitude estate. You have to give right of way, no? Doon sa servitude estate. Yan yung right of way concept. So, sa law nyo na pag-aralan yung concept ng right of way. Pero ganun yan, class. Pag bumili ka ng lupa, hindi mo alam, hindi naman obvious, wala naman nakalagay sa titulo na may burden na right of way or servitude, pwede mong habulin yan kay seller. No? Warranty against encumbrance or servitude. Kinds of easement or servitude: apparent easement, expressly made; non-apparent easement, no external indication of its existence. No? Pwede kasi yung right of way, apparently made, kitang-kita mo, visible, talagang dinadaanan nila. Tapos may sariling muhon yan, sa title, may sariling yan, walang nakalagay na naka-separate na yung right of way. That is an apparent easement. Non-apparent, no external indication, tignan mo, wala naman, parang wala naman. No, wala naman, tapos wala rin sa title. Tapos later on pala, nung pagpunta mo na, meron pala, sinasabi nung kabimang bahay, right of way namin to wala kaming daan sa likod. Easy access sa road, dito lang. No? So therefore, may problema pala, may encumbrance, may burden, may right of way issue. Pwede mong habulin yan kay seller. Warranty against servitude, encumbrance. Requisites for vendor's liability for immovable sold with easement. Again, number 1, must be non-apparent. Sabi ko nga, kasi pag apparent yan, no, as if winave yan. So, pwede mo maklaim yan pag non-apparent, hindi obvious. Not indicated in the agreement, must be of such nature that the vendee would not have acquired the immovable had he been aware thereof. Okay. That's it. I think that's it. So, good luck class on your final exam.